People post pictures, videos, songs, and other property to Facebook, Twitter, Instagram, and other digital media platforms every day, and many of those posts are shared. Some, however, are used or stolen by a competitor, a rival, or someone you don't even know. What are your rights? What recourse do you have, if any? How do you protect your intellectual property in the digital world? Tonight's live broadcast and live stream of insights on PBS Hawaii start now.
Aloha and welcome to Insights on PBS Hawaii. I'm Laura Yamada. Well, posting creative work or a selfie or anything you own on the internet can be kind of a double-edged sword. On one hand, it's a way to get your work seen and heard, or a way to share something fun. But on the other hand, whatever you posted could be ripe for the taking by online pirates, be they commercial or not. So what protections do you have? Our guests tonight include two attorneys who will address the legal issues of posting proprietary work online, and two people who are knowledgeable about technology and ethics. So we look forward to your participation in tonight's show. You can email, call, or tweet your questions, and you'll find a live stream of this program at pbshawaii.org and the PBS Hawaii Facebook page. All right, now to our guests. Jennifer Sunrise Winter is a professor in the School of Communications at the University of Hawaii at Manoa. Her research addresses policy and ethics related to emerging technologies, such as big data, artificial intelligence, and the Internet of Things. Billy Menkilau is an open educational resources technologist at UH Manoa, where he helps to build open resources on the web. Julia Brotman is an intellectual property attorney with Settlemyre Law. She protects her clients and business and intellectual property rights. And Makalika Noholova is an attorney for Microsoft Corporation. She is an intellectual property expert and can also speak to Native Hawaiian intellectual property concerns and protocols. So thank you so much, all of you, for joining us. This is such an interesting topic, and as we're talking about, so applicable to everybody these days. So maybe let's kind of start out this way. Let's talk about, in your perspective, how big of a concern this is, misappropriation, piracy of intellectual property on the internet. What's your take on just how big this scope is and how big of a problem this is?
I don't know if I would always want to phrase it as a problem, but it's definitely something that creators and everyday users should be thinking about and be aware of. It doesn't necessarily have to come with that negative connotation, I think. But there's a lot that people should probably know that they don't know, just in terms of, who owns the content that you're creating, whether it's whether you're a music creator or you're just a person with their iPhone taking photos, and then what happens when you post those things online, or when you're sending them to other people, when you're putting them in the cloud, things like that. People don't really think about that stuff, and it also gets into issues with like big data and things like that too, like who controls that, and then do you lose the ability to rein it back in if you didn't mean to let it go out there in the way that you did. Yeah.
And your thoughts? I mean, this is
Well, I agree wholeheartedly. One thing I'll say about it too is that we often don't really understand the consequences of what we're doing. So when we're sharing something online, we may not read thoroughly through the agreements. Our work may be repurposed in many ways, and it's very hard to keep track of once it is. I also think it might be good to open with mentioning that the law is always really struggling, I think, to keep up with these very rapid technical changes across an array of different developments.
Yeah, and I think the way that I put it was, probably misappropriation, piracy. So that's the sort of the legal, illegal side of things. But when we're just talking about the sharing of information and how we should be able to share it, there are definitely a lot of different camps as to how we should be thinking about and having this conversation.
Yeah, I think these days technology is amazing in terms of what we're able to do, sharing photos of our loved ones and our kids, reaching broad audiences. Individual creators can really reach so many people very quickly with, what seems like basic technology that didn't exist, 10 or 20 years ago. But then you get into the domain of copyright and actually where does the law come in and enforce certain things. And it gets a little bit tricky, especially when you consider that what you put on these online platforms, be it LinkedIn, Facebook, Twitter, what have you, you actually give a copy of everything, full rights to it, to those companies that own the platforms. And so we need to be thoughtful about not only who might be reusing, like individual people, but also what sort of the corporate interests are in what we're sharing on their platforms.
Yeah, that's a really good point, because I think a lot of people don't think about that. And a question we're going to ask was, can people actually copyright your own work? And I guess that sort of falls into what you've relinquished as far as your rights, whether you knew it or not.
Yeah, I mean, I think actually just kind of stepping back to that, what are people's expectations, right? So what are their expectations when they're the ones putting content out there? What are their expectations when they're consuming content? And that, interestingly, I think often it's easy to have different expectations depending which hat you're wearing. You put something online, it's really common for people to have expectations around control that differ from how they actually consume that content others post. So it's really interesting how, as the law is catching up, big part of that is because we as a society are catching up as to even what our expectations are here. A lot of what we do online has very direct analogs to offline ways of storing and sharing information, but there are aspects that are net new, and we have to figure out what that means. And right now, before we can really expect the law to get it right, we have to keep having dialogues like this to say, okay, well, what are your expectations? And depending on where you're from and your cultural context, that adds another layer of complexity because your expectations actually differ.
I think I was looking up, it's called the DMCA, is a Digital Millennium Copyright Act. Did I get that right?
Yes.
And it has to, if I'm not mistaken, it has to do with notification of either, I'm sure you'd be able to explain it better than I would. But this is it's a little outdated, isn't it?
Yeah, so the DMCA, I forget what year, I'm blanking on the year,
but it was 98 or something.
Okay, yeah, that sounds, I know it was in the 90s, yeah.
What is that? Explain to people what that is and how that is supposed to help, but it's a little more complicated than that today.
Yeah, so when it was enacted, the idea was like, okay, this is going to bring copyright law into this new modern digital era. And I think what you were referring to is probably the notice and takedown
right. So
process.
if you want to like, hey, somebody copyrighted my stuff. What's my rights? What can I do?
Yeah, so the safe harbor provision was designed to protect companies like Google, for example, who might be in their search results, if there are images that are coming up that are copyrighted, that are owned by other people, is that copyright infringement? But Google isn't creating the actual replica, and the safe harbor says that Google is just kind of this passive platform that allows this person who's infringing to post this thing and put it out there. But Google can take a step back and say, oh no, we couldn't control that. We had no way to jump in and say, no, that person can't be posting that infringing photo in this example.
And that can be a good thing and a bad thing, right? If you're talking about sharing of information.
Depends on if you're Google or if you're the person who owns the photo.
And it goes back to, again, expectations. Like, how does this align to offline modes of communicating and dealing with creative works and other types of intellectual property, and what aspects doesn't, and where are people's expectations? So, a big part of the DMCA was saying, look, now that we're online, a lot of people didn't realize that depending on how you're sharing online, there's a third party in the mix and a platform, right? So Google as a platform. And so what is the expectation around what the platform is going to do to protect your rights, right?
Yeah. And so one of the really frustrating things that I've come up against in my practice a lot recently is dealing with actually Amazon. So backing up a little, so the notice and takedown thing is that the DMCA requires these service providers, and they say, okay, we're not going to hold you accountable, but if someone comes and complains and says, hey, that person is infringing, that's my thing, they need to take it down.
Out there,
they need to have this, this like mechanism of communication, so that the person who's being infringed has a way to tell the infringer, you need to take my thing down.
Right.
And so I deal with this on Amazon a lot recently for some of my clients that are like clothing brands, they're fabric designers.
Hey,
and
this is not right.
And it doesn't always work the way that it should, and we've been really frustrated.
What are some examples? Give me an example.
So we have Okay, I'm trying to, confidentiality.
Okay. Don't say names.
Right, yeah. So there's a fabric designer who their work is protected. You know, they have these registered copyrights, and then and there's also trademark issues that come in. But the trademark, well, that's a separate issue also. But the DMCA is only dealing with copyright issues.
Okay, so that's something that people have to think of. They're different aspects.
Yeah,
of
they're
how it's
different things,
handled.
and they overlap, and so it's hard for us to lodge a complaint when they're through the DMCA, you know, notice and takedown process, when our issue doesn't fit into the box that Amazon is really, it literally is a form where they say, okay, you know, what's the infringing work, what's the copyright registration number, et cetera, and you send that in. But our issue goes further than the scope of the information that we are able to give them. And then we have no way to get to that actual infringer because we don't know who that seller is. The only way that we have to get there is through this form that Amazon lets us fill out. And so if they look at it and they say, oh no, that's not infringing, or you know, we don't see the trademark issue here, the trademark issue is still there. We have no way to find that person and track it down.
I saw a little factoid somewhere where I think it was 2016 or so, they had some numbers on Google, the number of complaints they got and notifications they got, and it was something like close to 1 billion in that 1 year. So context for people. So how do you, I mean, that just, it makes people sit there and go, we have rights, so what do we do? I think people are just sort of lost in all of this.
The other thing to think about is that once these platforms really got big and lots of people started sharing like millions and millions of pieces of media on them, the platforms were forced to, and folks lobbied to get them to come up with automated ways of detecting when there might be a valid DMCA claim, right? And so what happens a lot of times is that there's content that actually might fall under fair use, but that's been taken down automatically, and it's up to the person, the creator, who was potentially reusing something, but fairly, to petition after their content was taken down. It's a really tedious back and forth process. It actually puts individual remixers and reusers of content at a loss, fighting against an automated system on a platform that's been supported by original authors or rights holders.
So I think some people real quick wanted some definitions of things. For one, define fair use for people. Define fair use. There's some terms that I think people hear a lot of, but they haven't quite wrapped their brain around it. So how would you best define
most
fair
lawyers
use?
have a hard time wrapping their brain around fair use.
All right.
It means different things in different contexts, which is important to remember also. So copyright law, fair use is different than trademark law, fair use is different.
What might the average person need to try to wrap their brain around?
So copyrights are the rights you have to use certain work, certain creative work. And fair use, it's not rights to use work, but it's actually a defense on how you might have used something.
Okay.
So in my case, we talk about Creative Commons licenses, which are free tools you can put on your work to make them more shareable and tell people how they can use them. That goes a long way as opposed to folks just like trying to reuse content and then sort of having to rely on a defense of fair use. My use was fair, which always falls under a certain level of subjectivity, and there's certain criteria that you have to meet, like you're not actually infringing on their rights to make commercial use of the work, or getting in the way of their commercial interests and various things. There's rights which are sort of forward-leaning, and then fair use, which is more of a defense. That's how I look at it.
Okay.
Yeah.
I think you wanted to jump in, Jennifer.
I was just going to jump in and add to what Billy said about the automated takedowns. I know I heard a lot of complaints from creators, and as you mentioned, individual creators who felt that there was really an imbalance because of this. Because on one hand, you have things like the DCMA, which ultimately gave corporations a lot more power because they're the ones who have the tools to do this, and they're also the ones who have the money really to hire legal teams. And so the question now that I think we might want to get at a little bit as well, maybe Billy and others could chime in, is really what can the individual do in this sort of gross power imbalance now, is how I would call it.
Yeah, it's complicated. I think what you're getting at, though, is saying it's complicated because there's aspects that both on a social and a legal level, we actually want to make sure that no one's over-policing as well, right? So we often think about, this concept of taking things down as, policing your rights, going out and making sure that whether people are abusing your rights online or in any other context, that you're out there putting them on notice when they're doing that and asking them to remedy their behavior. And what you're saying is like there is a concern socially about the over-policing. And then I think it's fair to say that all of us have to be engaged in a conversation about getting it right. So, you know, the DMCA, reflecting a little bit about the moment in time in which it was put forward, tools have come a long way. I actually think that the DMCA is still
I think
very
Google
useful.
was in beta phase at that point.
Right. I mean, so that's the other thing is like, you know, you have technology that enables tons of sharing. I mean, people love, there's studies out there that show that when people can't get the content they expect, if there's even a delay of like half a second, they get frustrated. So we're enjoying the benefits of the platform. We're enjoying the benefits of like the mass sharing that this enables. But it's how then do we navigate all these issues, and we do all have to be engaged. And the law basically has to, it benefits when we all have the conversations and then are also just, frankly, understanding about where we are today and willing to iterate. Like, over time, the law absolutely will have to iterate and evolve. And we don't have to wait for the law to evolve if the law's not requiring enough of us and we have more that we can do, right? So we talked a little bit about how platforms, you know, since the 90s, technology has advanced and it is much easier for a platform to get more proactive than they were now. We're not fully there. There's still, you know, a lot to negotiate, but we all do have to be engaged in it, and it is complicated though, because people are as frustrated when a platform over-polices as they are when they under-police. Yeah. And getting that right and walking that line is easier said than done.
So we got a couple of interesting questions coming in, but people really do want to understand this. There's another term that people want to get right. Philip from the Big Island saying, can you define intellectual property? How do you define another like buzz term everybody hears about and you can't quite wrap their brain around?
Yeah, so
lucky you, I keep throwing
yeah, right. So it's intangible property, intangible things.
Property.
So it's and so copyright. We can kind of break down. Copyright, trademark, patents are kind of the big three that people think of when we talk about intellectual property. Okay. Copyrights are it's
not like a piece of artwork you made.
It's the artwork, but it's not it's not the canvas that the artwork is on, but it's that work of art. And what it really is we say it's like a bundle of sticks, and it's all these different rights. And so there's one stick is the right to reproduce that work, and another stick is the right to display that work, and another stick is the right to adapt or create derivative works. And so that's actually where a lot of the fair use questions come in, is when we're making adaptations that you're infringing, even if you're not just directly copying something and reproducing it. If you're inspired by something, depending on how inspired you are by it, you might actually just be infringing that right to adapt and create derivative works. So we have copyrights, which is it's the expressions of an idea that are fixed in a tangible medium. So we talk about art, visual art, as well as like sculptures, things like that, fabric designs, music once it's been written down or recorded, architecture, choreography. All of these things are protected by copyrights.
And really, this opens up interesting discussions as to the level of technology that we have today. And what that means. And so this kind of leads into a discussion we were having earlier about AI and artificial intelligence, and also things that are created based on algorithms or things like that, which kind of goes beyond sort of a human being in a sense, even though there was obviously intent by a human being. So here's a question. Who owns a copyright on artwork or creative pieces generated by AI or artificial intelligence? Anybody want to try take a stab at that one?
I'd love to. So.
Yeah.
That's a great question. One thing that I've noticed when I'm teaching my classes more recently, the last 3 or 4 years, students have been showing me like amazing music or even some poems and things that AI has created.
Really?
There's a lot of companies now that are marketing music, for example, that's created by an AI. And what they've done is they've gone back to the public domain, that is works that are freely usable and are no longer held under copyright, classical music, for example, and they've trained AI to basically create its own, and then that becomes something that they want to then have as the corporate creation. And so the answer is no one knows, because right now, I think, and I'll defer to the lawyers here, my understanding is that really there's nothing to say that a technology, or in this case, there was a famous example of the animal, the monkey that took the photo, allegedly, right? And that panned out to be that essentially you had to be a human or a corporation in order to have these rights.
So then that was public domain.
Yeah,
because
the monkey pressed the trigger on
The
the
monkey
camera
pressed the
and took the
trigger.
photo,
Really?
Yeah.
but it wasn't his camera, and the photographer in some way had set up the shot for it to be possible, but because the photographer didn't actually do the work and create it, then
such a
it was
fascinating
debatable,
conversation.
right? So.
Yeah.
Interesting.
That was really interesting.
So what are your thoughts too when it comes to thinking about things like AI and algorithms and things that are generated by something that's maybe not in the immediate human being?
Sure. I think one interesting area where that's coming into play is with facial recognition and sort of massive databases of people's faces. And now there are algorithms that can actually recreate what a person might look like, but it's not actually a photo of a real person. And so it's not a real person, so it's not representing an individual, and it's not created by an individual. And so technically it might actually be in the public domain. So we're seeing an area where there might actually be a regenerative public domain that's actually growing, as opposed to work that falls out of copyright. We have work that enters the public domain not under copyright, immediately.
Okay, so I got the whiz guy chirping in my ear. Public domain, define that for people. We want to make sure people understand these terms that are floating through this conversation.
Sure. And the lawyer, I may defer to the lawyers after this. So public domain, that's
You get paid extra. No, I'm kidding.
public domain, it's an area of work. It's works enter the public domain after copyright has expired, or
Okay.
in the U.S. if it's work created by a federal government entity or
Okay.
person, in the line of their work.
And also the individual can then give that to public domain as well. They can. Is that not correct?
There are
They can
tools,
Sort of essentially, sort of. I don't know. You might be able to say it better. Relinquish their rights in a sense because they want it to be allowed for public domain.
There's a tool called CC0, Creative Commons 0, that's essentially placing your work, it's relinquishing all rights to your work and placing it as close as possible to the public domain, but it's not actually in the public domain.
Okay.
It's very close.
I mean, the effect is that if it's in the public domain, it means that you can use it without fear of someone's going to come and, claim that they own it, and so you have to stop what you're doing.
Yeah, you can do anything
really
with
the
it
effect of it
as
being
long as you don't say that you created it.
Okay. I'm sorry. I wasn't sure if I stopped you in your train of thought there, but. So here's another question too from someone anonymous. Caller wants to know if an owner is selling property, but a broker advertises that same property online as "quote unquote" sold, even though it's not sold. Can the owner of a property sue that broker? Is that possible? I'll say that again. I know, yeah. We're testing you guys. If an owner is selling property, but a broker advertises that same property online, so someone else advertises it as sold, because they're kind of maybe trying to game the system a little bit, even though it's not sold, can that owner, the actual owner of the property, sue the broker or the person that went on there and said, hey, it's sold?
Well, you can sue anyone for anything. That's my lawyerly answer. Are we talking about intellectual property specifically?
I know. Maybe this turned a little bit of a
Indigenous
left turn.
interference.
We took a soft left on this one. All right, so let's get back to some of the other questions that are a little more involved here. So the answer is you can sue anyone. Let's talk about transferring data. Does anything change when we're talking about transferring data between different types of vessels, or say if it's, are there different types of protections if it's transferred in a certain way? Does that go back to the whole third-party thing? How do you sort of...
Give us an example.
Oh, gosh. Let's see.
Do you mean transferring rights or transferring the actual?
Can you protect it when if you're transferring data, say from, I don't know, I guess from one platform to another, or from say Facebook to another type of a site. Is there a way within that transferring process that you can better assure that you're protecting that data? How does that, or are you really just opening yourself up once you start to move that property around?
One
or
small
should
note,
it stick?
I think the copyrightability of data
It
itself,
sticks.
which are facts, is sort of contestable. And
Okay.
Yeah, so you want to think about and I think maybe what you're sort of getting at, or maybe not, but I'll say it anyway, is say you're on Twitter and you see something that someone else posted and it's funny and you want to repost it onto Twitter or onto Facebook or something like that, what rights are implicated and what do you need to think about? Is that kind of the question?
Sure.
And so this is, I think we were kind of talking about this earlier, people don't always think about who owns this, when we as everyday social media users are infringing. And we kind of assume that if something is out there that it means that we can repost it or do things with it, but that's not necessarily true. And we find that artists and people, a lot of like digital artists, people who are doing things that are very easily shareable, will find their stuff being posted and then sometimes even used on it can kind of escalate, or it can go viral, or you can end up someone else is profiting off of your thing and you didn't even know how that happened. And a lot of times, especially in this kind of viral culture, there's this attitude or idea that people should be excited that their thing is getting seen even though they're not getting paid for it. And that's something that I get really defensive of my, artist, creator clients who kind of get stuck in that mentality too. And it's like, hey, you know what? You spent time and energy making this thing, and maybe it shouldn't be all over the place for free just because someone else shared it. Maybe you should be properly compensated for this. And you find that like news organizations and kind of bigger media companies are still really diligent for the most part about those kinds of things. If a newscaster wants to, someone posts a video on Twitter of some crime that they saw happening, if the news organization wants to use that video, they're going to pay for it. They're not going to just take it and repost it. And so there are these kind of bigger organizations that still see the value in that. But on a day-to-day basis, people tend to not worry about that so much, or not feel like they deserve that compensation or deserve to have their rights protected in that way.
I was going to say these platforms are designed with this concept of shareability, and they're built with affordances which allow you to do things like retweet or share or whatever. So I think part of the issue is then whether it's attributed to the original person that posted it, whoever owned it, or whether you're taking someone else's content that you don't have the rights to and putting it up there to begin with. And so there's a lot of complicated issues here, but this is how these large companies flourish. They want to have these retweets. They want to have as much data as possible, as many users as possible. And of course, many users are motivated by that as well. So if you are the artist and you've put your work up and you're sharing it, it doesn't mean that you should expect that someone will steal it and use it in another context without attribution. But that's where this kind of becomes a sticky issue, right?
Mm-hmm. And something to keep in mind is that platforms like Twitter, like Facebook, they don't make content. Mm-hmm. They host content and they make content shareable, but they don't actually make anything other than like the roads on which we send things out and the channels, right?
So talk a little bit more about Creative Commons and Open Educational Resources, that initiative. Sort of just explain to people who don't know, aren't as familiar with how it came about and what the purpose is and where you see it moving forward.
Sure. So the Creative Commons licenses, they're free legal tools anybody can use. They can put on their work to make them more shareable, right? So
you can literally look up Creative Commons and it would...
Yeah, creativecommons.org is where you go. So essentially the OER, Open Educational Resources movement, is a segment of sort of the open sharing movement. And that's focused on cost savings for students. At UH, I run the OER project. And essentially we are offsetting the cost of textbooks and materials for students by providing free options, so free of cost, but also they have a CC license on them so the instructors can actually change and adapt the materials to fit their teaching style and to fit the needs of their students. So it's a twofold sort of process, which would not be possible if you were still working in an all rights reserved sort of domain here.
So that's interesting. That I didn't realize they could, to a degree, change the actual sort of content. And how is that? How do you then, if we're, I guess, we're floating in between sort of standardization of certain types of things, whether it be education or other types of information sharing, and not, because we want it to be open and free and be able to be creative about their thought processes. So how do you kind of sort of balance that, or sort of how do you have that discussion when you're talking about opening up and sort of freeing this type of information, sharing so that people can use it the way that they feel is most appropriate in their context?
Yeah, I think in education specifically, education is about sharing. It's about sharing knowledge. It's about sharing resources and that sort of thing. And so what we do is look for the motivated faculty that are used to sort of like, writing their own notes in the margins and creating their own materials kind of around an existing book. And we say, hey, we're going to find you an existing book off the shelf that you can actually like open it up, reorder things, add your own content to them, and share it with your students. And your students never lose access to it. You can have a whole teaching team, a whole curriculum team working together. We have teams working across campuses in the UH system doing this kind of thing. So it's really sort of a broad area where a single contribution in the form of an OER or an open textbook can help like literally thousands of students. So our own project at UH Manoa, we give small grants to faculty that are willing to do this, spend the time to adopt and adapt a book. We invested about $80,000 over 2 years, and we affected more than 12,000 student enrollments. And when you figure the average cost of a textbook, some are way more expensive, some are less expensive, right around $100. We're looking at like $1.2 million. So pretty good ROI, and it's all based on this idea that, it's with an OER, I can make you a copy of my curriculum, and it doesn't take away from what I have, but you also have an equal copy that you can do what you want with it. And the CC licenses sort of facilitate that process.
Does that make you cringe a little bit?
No. I think it's really important for us to be able to think about things in different ways and be more flexible, as long as everyone knows what they're getting into and they understand, like you were saying earlier, what the consequences are. I think when I start cringing is when people don't know their rights and they don't understand why things are happening the way that they are. They don't know what their options are. So they don't even know what they may or may not be giving up. That's when I go, ugh.
Yeah, and here's another question that kind of sort of lends itself to that. What about this scenario when we're talking about education? So a classroom teacher who shares ideas on Pinterest. This is what they're worried about. A classroom teacher shares their idea on Pinterest, are at risk of her school claiming ownership of that.
Ooh.
Because she's employed by the school, and possibly claiming some revenue of her intellectual property. So say, if I'm representing this school, I'm employed by this school, but I posted it as an individual. It's my intellectual property in my mind. Have things changed because of how I posted it and what my position is?
It depends on what the employment contract is.
Okay, read the contract.
The contract with the school probably says, if lesson plans are, your own versus going to be the property of the school. That's kind of the starting point.
Yeah, and if it was done on school time, and if it was based on other material that they got from the school, they're like, it depends.
Yeah,
every lawyer will say it always depends.
But the internet in this scenario just happens to be a medium by which the person is sharing it. There's nothing about this that is particularly about the internet or going online. It's just, you could ask the same question if she were to make photocopies and share them at, a conference. It would be the same question. Yeah.
Right. The other piece is that ideas aren't necessarily copyrightable. It's the idea in a fixed, tangible form that is copyrightable, right? So people browse the internet. Oh, I read this lesson plan. It's really good. But if you're not actually making a copy of that lesson plan and pulling directly from that content, and actually, making your own adaptation that doesn't draw directly from it, that might not actually be copyright infringement.
So I guess that's where people would have a tough time, though, is deciphering between the two. Like, at what point are you sort of crossing over into something that is copyright in that sense, or if you're sort of using sort of the concepts in a way that quote unquote generally apply to what you're trying to do. It follows some general standards of some kind, but you've adapted it to a degree that wouldn't necessarily make that original plan recognizable. I don't know. To me, that's kind of a tough area for a teacher or somebody who's sort of, I can just absolutely see that scenario happening all the time. Like, looking up online, looking for some reference points as to how they can make their own curriculum and their own plan, and just pulling from different things that they've seen online. Mm-hmm. How would they know when it's then become copyright? I think that's would be tough.
I mean, that's at the core, right?
It is, yeah.
This is the balance. It's sharing has this awesome potential for everyone to benefit from what you're sharing. Mm-hmm. And then intellectual property rights are about providing defined monopolies so that people can maintain economic interests in that creativity. So yeah, that's at the core of it, and it predates the internet.
Okay, so here's another question. I knew some specific ones would come out, specific scenarios. If a photographer uses a watermark or symbol on his or her photos when publishing, will the work be protected? Will the watermark do it?
The watermark does not do it, but the work will be protected.
The what?
The work will be protected. So copyright, you have copyright protection as soon as your work is fixed in a tangible medium of expression. You can register it with the Copyright Office, which is a good idea.
And that's what you mean by that,
Yes.
first phrase.
Yeah,
Okay.
so, but if I, like that question that's written down there,
Yeah.
it's fixed in a tangible medium of expression.
By putting the watermark on it? Or,
No, just by writing it down on the piece of paper. So you don't have to do anything. That's not saying that you shouldn't do other things, but just, if I got a napkin and drew a picture of a bird, like that would be protected by copyright law. But if you want to have other protections, like the ability to sue and get certain kinds of damages,
I see.
then you want to have your works registered with the Copyright Office.
Right, so technically it would be protected in that sense, but if you are getting into the legal realm of things and wanting to take action of some kind, you need further protections.
Yeah, and then the copyright notice, the symbol, the C in the circle, that is really helpful to put other people on notice, so that if I have my napkin drawing with the bird and it has the copyright symbol and then I leave it here, someone walking through the studio would say, oh, she's claiming rights on that. I'm not going to go rip that off.
So you could literally draw a little C. I'm getting really
yeah, and it's just it used to be a requirement under the old Copyright Act, the 1909 Act. It was a requirement if you were going to put something out there, you had to have the copyright notice. But now it's not a requirement. It's just a good idea because it lets people know. So do you see it the same
way? As far as, okay, that's enough, or that is enough an indicator, and that really should draw the line, even if we're trying to be open about how we share information.
Yeah, so copyright in the U.S. is automatic. You don't have to register it for you to actually have copyrights to a work.
Okay.
Registering it is a good idea in certain circumstances, but it's not necessary at all. And so to speak to the question in terms of having a watermark, that's one tactic for sort of putting off folks that might potentially reuse your work without permission. Another tactic for like photographers per se, on their website, they might put a really low resolution version of the work that you would, if you tried to print it, it looked terrible. But that sort of, the watermark or the low res version might inspire you to actually reach out and contact the creator and actually like compensate them for their creativity.
It shows a little additional intent too, doesn't it?
I think this is touching on some other really important issue, which is even if you have copyright, it's very hard to enforce necessarily, right? So how would you know, for example, that someone is using your work? You would have to go through an extensive process of either hiring someone to do like Google reverse image searches, which would enable you to match that photo across
Google
the web.
reverse image searches?
Yeah, there's like a thing in Google where you could put an image and then it'll look for similar images. So you might be able to systematically do that, but it would be very time intensive, it'd be very hard. So there are some automated tools that are emerging which are being used by individuals that are seeking to address that. I'm not sure how effective they are, but that's one thing that I've seen like the last 3 or 4 years. There's been a number of automated tools that you can join a site, for example, that will attempt to do all of these things for you. Even to some degree have these international law teams. I'm sure it's certainly not free, but there's an effort to try and track these things down. So the enforceability is the part that I think a lot of people get stuck on. Yeah. You have the right, but how do you even know if it's been violated, and how would you get damages without a lengthy process? Maybe you can, or.
Yeah, and it's expensive, and I think the practical solutions that you were talking about are really important because, we always tell people like, yes, if you want to protect your stuff, register it, but be strategic with this. If you have a ton of works, it's going to get expensive just to do those registrations. People often want to hire a lawyer to do it, and we certainly will help with that. But if it's someone who's like writing a bunch of music or they're taking a bunch of photos and they're doing a whole bunch of things, I try to just teach them how to do it once so that they can do it themselves. Otherwise, it's not worth it. I shouldn't say that, but it can just be so expensive just to kind of jump through these hoops. And then when you get to the enforcement stage too, it's expensive. It's expensive to hire lawyers. It's expensive to, certainly to file a lawsuit, but even just at the cease and desist letter stage, it can be a lot of work, and you have to really think about whether it's worth it with any given infringement, I think.
Yeah, the strategies, there's so many strategies that you can employ. And there's this whole spectrum in terms of how aggressive you get and how much of investment you put into that and not. And so it is a great idea to get savvy as to how this stuff works. What are the different tools in the toolbox, right? So we talked a little bit at the beginning of the show about the DMCA, which kind of gets towards like how do you work with a third-party platform. So, I make an image, you post it. My beef is really with you, right? But you own the social media network on which that's getting shared. So now we're looping you into it because I could either sue you or I could get you to take it down, and that's so much faster, right? And so figuring out like, well, okay, you're going to say, but wait a minute, I'm not a judge and jury. You're going to say like, yeah, that's fair use, right? Don't over-police it. So it gets complicated super fast, right? And so then you say, okay, well, on the one hand, like, great that I can even go to you, right? That's even an option. But what are you going to want, both so that it's practical for you to engage and participate in this dispute in any manner, and feel good that you're making the right choice, right? Because we are asking that third party to make a choice that traditionally we would have asked a judge or a jury to make, right? And how comfortable how comfortable are you that we would be asking a third party who just happens to be a technology company to act as if they're a judge and jury, right? So we think about that.
And there are some people that think that technology companies should be doing a lot more because they're these big technology companies that probably have the resources to figure out these algorithms, and instead of artists having to go pay these other resources to do that whatever tracking they're doing, some people think that should be on the tech companies. They're offering this thing, they've created this world where people can post and share and do things on their sites, then why aren't they taking more initiative to make sure that everybody's rights are being protected? So.
And I know that's tougher to wrap their brain around, but I want to make sure we get to another area that I think is really an interesting part of this conversation. We were talking about Indigenous intellectual property and sort of what that means and what you sort of see happen. We had talked about a case I think that would resonate with people here a lot that happened not that long ago about aloha poke and the name aloha or the word aloha and whether or not, and this I think was a Chicago company that basically sent out cease and desist notices to everybody here from Chicago here saying, hey, anybody who has the word aloha or aloha poke in any of their anything, you can't because we have rights to it. So what are your talk about that a little bit about what you've seen and sort of what's happening with that conversation.
Yeah, it's super timely, actually. It's totally a coincidence, but I was here, it's been about exactly a year because I remember being here last October talking to a couple of different audiences about this topic. So that triggers a couple of different things calling on things we've talked about here. One would be, first of all, how aggressive should one be as you start out? So again, over-policing, under-policing, thinking about that as someone who believes you own a brand or a creative work or whatever the intellectual property form might be, like that's one thing. So you might say, first off, you kind of laid it out as like this aggressive company, right? So that's one thing I would just help people think about. It's like nobody wants to be cheated, but at the same time, like reflect on whether, like how are you showing up to an objective third party, right? So that's one thing. The second thing is, where does the law sit on this, right? So okay, this company's made this choice, they're going to take this action, like is there good basis for that in the law? And what's your I think you're having your reaction. Everybody has a reaction in Hawaii about how that what was good about that and what was bad.
What's interesting to people is when we get into the cultural aspect of it, cultural terms, cultural phrases, how does that shift the conversation, or how do you sort of view how we should think about that conversation when we get into that realm?
Yeah, in that particular instance, I think what's hard is we have a law that attempts to provide rules that works for everyone in terms of how we control these intangibles, right? These acts of creativity. And the reality is we're a country composed of a lot of different communities that have a lot of different sensibilities about what is right and fair and good about those kinds of content. And so Aloha Poke, I think, tees up numerous things, but one of them is how is that balance working out, right? When you're a community, so I think what's happening in the Native Hawaiian community is this perception that like this should not even be owned. So way over aggressive. So
the word aloha.
The word aloha shouldn't be owned. It triggered a lot of questions around what aspects of our language is ownable, and by ownable, what does that even mean? Does that mean that I can't say it? Does that mean I can't use it commercially? Do we want nobody to own it? And that's one of the things that I think as a community, I think it's a good case for teeing up a robust conversation in the community. Like, what do we even want, right? So,
what happened with that case? How did it end?
So there was, I think, multiple matters going on there because there were multiple small businesses that the Chicago company was claiming were infringing. Right, and so I think the different, I'm not sure how many companies actually. I heard of 2 different companies that were received letters, and I believe one just chose to rename because this is they felt that it was an expensive process and all that. Yeah,
that's also the reality.
My understanding is the second company. Again, I'm kind of like a third party here, but my understanding is they actually just persisted. That was my understanding, and just I don't think anything happened. But when I last checked at it, the company in Chicago had continued the process of owning that brand. So I believe it's still active on the Federal Trademark Register, but don't quote me on that. I'd have to check that. Does anyone know?
What comes out of that? Like, how do we then sort of take what happened and move that into the next
so what's the options in the law as it is today? That's like one conversation, right? Which is basically, somebody would have to challenge that trademark as trademarkable. And I think probably the most compelling argument that could be made under current law is that it's not distinctive. That term aloha, well, poke for a poke shop is not distinctive. That's a generic term. And then you essentially say like the term aloha is non-distinctive as well because it's so ubiquitous. And so you basically say, look, that's not distinctive enough to be a brand. And then there's other things people could do, like if there's a company who'd used it prior to the Chicago company, there's tools to claim that you got it first, basically. So there's different things you could do with the current law. But I think the interesting question people have is it even right that that could be owned? And how are we thinking about different languages? So one of the things I kind of challenge people with, and I'm a super advocate of my people and our culture and traditional knowledge, but how does this work if it's a language that's much more commonly spoken, right? So how does this work if it's a term in Chinese? Like we have folks, one of the things that really triggered people about this incident was that the company that was enforcing the trademark right is non-Hawaiian. And so there was this offense of like, well, I don't know that this should be owned at all.
How can they do that?
But also, definitely not you, right? Because you're not in our community. And I get that. I totally understand that. And at the same time, we're letting people of Italian descent own Chinese restaurants and brand them with Chinese names. And so you kind of have to think about like how would this work not just in our own community, but kind of generally. And all of that said, what I think is where I do think that there's a good argument to be made is this issue of non-distinctiveness. So under the current law, I think what you'd want to say is, especially in these terms that are super ubiquitous and it's almost it's offensive. I mean, I actually think it is offensive to our culture to tell someone that you could ever try to monopolize that word in particular. So at some level, you try to get it kind of becomes specific to the term, actually. I'm not sure that you just come up with a broad swath rule around it. But that's just trademark. I mean, there's cultural implications to all the different kinds of IP. And
so people need to really, this needs to be an ongoing discussion about what it is that people really want and what type of parameters you might want to try to, that's fair, I guess, or makes sense.
It's a little bit unfortunate that the Aloha Poke case is what kind of brought these issues to the forefront. But now that they're here, I think a discussion probably needs to be had.
Yeah.
I think it's also a question, is this even a beef to have with the USPTO, or is
What's the USPTO?
Sorry, it's the United States Patent and Trademark Office. So they're the ones that issue the registration. Is it their responsibility to say, hey, this is cultural appropriation, not cool, you guys shouldn't get this mark? Or is it on the people in Chicago who are using Aloha Poke and then trying to prevent other local people from using it here? Is it on them to kind of, feel like they are okay doing that and that they're not, offending the rest of, Hawaii's people? And how do we have those conversations that, maybe the law isn't the best way to address that. It certainly isn't right now because it really doesn't accommodate those kinds of arguments. But
yeah, but I think all involved. I mean, I think it's fair to say that we need to have these conversations. Like Indigenous people need to have those conversations in their communities, and we need to be having those conversations with all the other stakeholders, right? So with our lawmakers, with our intellectual property office, and gaining awareness so that we can come at some sort of solution that we're all leaning in to do the right thing, right? So I do think that people, individual parties, a super aggressive owner of intellectual property might not be leaned in to do the right thing, but I think these groups in broad terms actually are trying to do the right thing. But when you've got that cultural diversity, it requires work. It really requires work.
So let me get to a few other questions, just kind of a variety of questions here. Caller applied to Harvard Medical School, and the application indicates that all intellectual property and all works created by students while enrolled belongs to the university. Is this true in school? Is this common? Is this what students should expect?
if it's a contract and that's what they sign, then that's true.
So it could vary, but yeah.
Yeah, so it depends, usually, and I think we were kind of getting at this earlier too with the question of employment. Yeah. So if you create this is under the Copyright Act, so this doesn't refer to like inventions and patents, trademarks, but at least with respect to copyrightable works, if you create something within the scope of your employment, and there's a whole test, and it's the same test that the IRS uses. So if you're using the university computers and you're doing it, you show up to class, you spend this much time making this thing, it's what the professor told you to make, et cetera, it's pretty likely going to be a work made for hire, which means that the university would be the original owner.
And I think this question from Lori on Kauai really relates it to a city and state employee. If you create an innovative program while you're at work, who has rights to that program, the employee or the employer? Would that kind of fall within the same argument of what you need to think about?
Yeah,
yeah, it's probably in their employment contract. If it's done on work time as a part of their regular duties, it's probably either shared ownership or it's the property of their employer. Speaking to the Harvard application, the Harvard sort of terms there, that's sort of an interesting dynamic, primarily because the student is ostensibly paying money to Harvard, and then also they're giving away their IP to Harvard to be exploited, and that's sort of a double whammy that I'm not sure is actually favoring the student at all. So if I were a student, I would say, sure, I'd love to come and here's my grants and scholarships, but I'm actually going to retain rights to everything I create here.
Well, we only actually have a few minutes left, so I just want to make sure that I ask you guys this question. So for the average person out there, I think typically, they want to know, okay, if I post sort of family picture online, or if there's a picture of me that I posted online and was used somewhere else, what's logically or reasonably could they do? What would you suggest? They need to really think of right up front to try and protect themselves somewhat if they're concerned about that. This is the average Joe.
I would say just one thing is that a lot of times there could actually be arguments about who owns it. So any evidence you have that you created, even the photo, the work, even the underlying, you can have like date and location.
Yeah, what might be some evidence? When you say evidence, what do you mean by evidence?
Well, if it was a photo, obviously you would have some underlying code underneath the photo, unless you've stripped it, that would talk about date, location, et cetera. And of course, if you're the subject, that's going to help. If it's a landscape, you're going to need to indicate somehow that you created it. Someone could easily say that they did. So anything you have that shows that it came off your camera at a certain date and time, any evidence trail that you can keep would be to your benefit.
Yeah, and I would add, when you mentioned, if you're the subject of the photo, so Hawaii recognizes the right of publicity. So people have the right, the exclusive right to exploit their image, their name, their voice, their signature, their persona for commercial purposes. So if someone else takes that family photo and uses it in a meme or in an ad or something, if they're making money off of that, you can't do that.
Yeah. So
and so, so you do have, copyright law isn't the only thing that can protect you in some of these circumstances as well.
You wanted to chirp in, Billy?
Yeah, I mean, in terms of posting things on social media platforms, pictures of yourself, family, that kind of thing, I'm sort of more leaning towards being more conservative about that. And I actually would not post pictures of my family and friends on those platforms for these copyright issues and privacy issues. I prefer to use encrypted networks and sort of like only you and I will get this photo and nobody in between, and that's sort of where it stays. Because really, once it goes out there on a platform, the rights are given away and you don't actually know where it's going to stop. It's really easy to make copies of it and other people might find it and use it in ways you don't expect. And so when it comes to like family and friends and personal things, I just don't share things online.
Yeah, that's good.
Maybe something people really have to sort of think about as far as what it is that they want, what do they want to share. Any other thoughts as to what people need to think about? Just the average person, with our yeah, we got about 30 seconds left. Just your thoughts on what they need to think about.
Yeah, I think if the average person is just worried about sensitive information, right? Yeah. Sensitive imagery. I mean, this is such a complex area. So the more that you can do to just be generally savvy as to what does it mean when I post it? Where do I post it? Like, how does that work? Who can see it? Like, getting savvy is important. And a lot of the big platforms are actually, they really do want people to be happy with the experience.
True, that's the thing. And I know that we continue this conversation even more, but we just ran out of time. Okay. But thank you so much, all of you, for joining us tonight. And we thank our guest, Jennifer Sunrise Witcher, professor in the School of Communications at UH Manoa, Julia Brotman, intellectual property attorney, Billy Maggie Lau, open educational resources technologies at UH Manoa, and Makalika Naho'ova, intellectual property attorney. Thank you so much again for all joining us. All right, next week on Insights, who manages our water supply? And can you imagine an entire day without access to water? Join us then. I'm Laurie Yamada for Insights on PBS Hawaii, where we hope.